Look, everyone's on that. Yeah. I'd rather
Third year.
This is remedies, and it's listed on the syllabus as section 4, which means that we've got to pick up the pace a little because we should already be on section 5, which will be on Thursday. I've got to tell you though, there is a chance. I have a hearing in the afternoon on Thursday at the MCAD, and there is a chance it shouldn't be that long, but it may go. If it goes long, I'll have to post a note. So which means we'll have to do both section 5 and 6 next week. If that, in fact, that happens, that the hearing takes longer, and then, obviously you never know how long a hearing will take, but it shouldn't be that long. I'm just getting into the case though, so I really admit I may be underestimating the problems with it. But today, so they'll post that if that's an issue and you'll be aware of it. But today we have to deal with section 4, which I've called attorneys' rights and obligations. We also have a couple of rules to look at here, one of which is Rule 11, obviously very important, and the other is Rule 23, also important, but not used that often by most people. If you do class actions, obviously you would use it a lot, and you would virtually oftentimes have a practice limited to class actions because it's kind of a specialized, it is a specialized practice. But let's talk a little bit of Rule 11 because that affects all sorts of civil litigation that you affix your name to. And as you know, as we've talked from time to time, what Rule 11 requires you to do is to make sure that the complaints you file, the answers you file, the pleadings you file in court are sufficiently meritorious that they should bear your signature. And when we say sufficiently meritorious, what we mean is that they are factually and legally supported, that they're not interposed for any improper purpose such as harassment or delay, that they're either based on existing law or good faith belief in reversal of existing law. And so when you put your name and your Board of Bar Overseers number on that pleading, what that tells the court is that you have made that investigation factually and legally such that you're comfortable that should a Rule 11 challenge come to it, that you can justify what your actions were. And I mean, I could go into Rule 11, but you should look at it because it talks about the specific representations, in essence, you're making to the court when you sign that pleading. And also it talks about the sanctions that the court can impose on you in the event that they feel that Rule 11 has been violated. And that's something that you really have to recognize, is that it isn't necessarily limited to a monetary sanction. They can, in fact, apply other sanctions as well to you personally. So it's not just, well, I'll turn it over to my insurance carrier or the client will pay it. If it's a Rule 11 sanction, it's because of your failure to do the appropriate thing as a professional, and the sanction runs against you personally. The other part of it that you ought to recognize is that it really is the start of likely your problems, because a Rule 11 violation by many judges would also amount to them informing the Board of Bar Overseers that they think that your behavior was inappropriate and failed to meet an appropriate standard in court. Since your Board of Bar Overseers number is on your pleading, it's relatively easy then for the court to make a reference as well. I've always said to you guys in class when we talked about this before, I think Rule 11 is a good rule even if it didn't exist. It's a good rule as a lawyer, as a professional, because what it asks you to do, make sure that you should do, is before you run off to court and sign a pleading, whether it is the complaint or the answer, that you haven't just listened to your client, accepted everything at face value, failed to research it, and just run off to court. Because that's a recipe for disaster. I don't want to sound overly cynical, but having practiced law for a long time now, the fact is you can almost never take what someone tells you at face value, because even if they're giving you 100% of the truth, which isn't really likely, because we color things as we see them. It's not necessarily what actually took place, it's how we felt that they took place, how we experienced it. So it's not that they're even intentionally lying, but the fact is that even if they were being 100% accurate with you and telling you what took place, you still need to know that there's support for it, right? You still need to know that there's proof of what they've said, other than just a he said, she said case. You need to know that the documentation supports what they say took place. You need to know that not only does the documentation, the evidence, and hopefully other witnesses support what they say, but then the law says that there's a remedy for that wrong. And you don't know all of that until you've done a reasonable level of investigation, both factually and legally, to justify filing that suit. And you don't want to get 1,000 hours into a case and then realize that the case was a dog, the case is one you shouldn't have attached your name or reputation to. That all should be done early. And if you do it early, there's going to be fewer surprises later down the road. There's still going to be surprises, but there'll be fewer of them if you, in fact, take the time to dot your I's and cross your T's at the outset. It's the ones that we run off on, trying to help someone that we failed to follow our own internal procedures that we've set up, that halfway down the line we realize, okay, this is a problem. And when you haven't dotted your I's and crossed your T's, when you have taken shortcuts, now you know you're a little vulnerable when the attack does come. And I'll be honest with you, older, more experienced lawyers are going to challenge you as to whether, in fact, you've done your due diligence. And some will do it as a matter of course to try and bully and intimidate you. And if you haven't done it, and if you're advancing, it's not clearly a contract case, it's something other than that, then the fact is you don't want to have to start to check after that challenge comes. You want to have known that you're on solid footing before the challenge ever comes, because then you could be an effective advocate. But if you're on your heels the whole time, you're not going to be an effective advocate. Sooner or later, I'm going to be past you. You want to be on the balls of your feet. You want to keep moving forward. And if you're worried about what you may have done personally in your own exposure, it's a little difficult to be a forceful advocate when you're worried about your back instead of your clients. And so I really think Rule 11 is important, not just because of the monetary sanctions and your reputation that's involved when you're sanctioned. But the fact is, it's just good business, especially if you're taking cases on a contingent basis. A lot of civil cases are, whether they're business disputes or injury cases or individual cases. A lot of those are on a contingent basis. You damn well better know that there's a return on your investment of time and money in that case. The only way you know that is if you've done your investigation at the outset. There's a million good reasons why you need to follow carefully Rule 11, and not just the jot and tittle of the rule, but the spirit of it, because it not only should keep you out of trouble, too much trouble, but it also should make sure that you're able to run your business profitably and professionally. And in the long run, that's most important as a lawyer, is that people respect who you are and what you do in the cases that you attach your name to. Because you, whether we like it or not, you're ultimately known, at least in part, by the clients that you represent. Questions on Rule 11? By the way, I've seen lawyers find it's not really truly Rule 11, but late for court, especially in federal court, $500. So those of you that are tardy or unprofessional in other ways should now take heart and start to reform your ways, because there's a lot of other things we will get criticized for, not returning phone calls, things along those lines, that you need to try and step up your game a little bit, because I've always felt that I don't even want, other than my annual renewal, I don't want the Board of Bar Overseers to even know my name. I don't want to see anything from them. But, you know, you drive enough miles, sooner or later you get in a car wreck. You want to at least make sure that you're not getting in a car wreck every month. And you don't want them to have to, you don't want to have to justify anything you've done, period. So if you're careful, you should be able to avoid those train wrecks. Questions on that? By the way, there's others, I've seen other sanctions I've told, said on occasion. I saw one, I'd rather pay the money. It said that the judge was sending the lawyer to a remedial writing course because his briefs and pleadings were incomprehensible and looked like they were written by a third grader. And then it named the lawyer. I'd rather give you the $500 than have that. So sometimes it's more than money. That's worrisome. Rule 23. Let's talk quickly about class actions. Then I want to go into your lawyer problems. Class actions are brought on behalf of some named representatives who are representing a group of people, what we say is a group too numerous for joinder, right? A group too numerous for joinder who have been injured as a result of common questions of law effect. You've seen the notices in the newspaper, whether it's cell phone or overcharges of cable, or at some point it'll be overcharges for your law books. Well, really, that's a racket now, right? Over $200 for a lot of your books. So, I mean, something seems wrong about that. And my guess is, at least in part, it's antitrust, since Western Foundation are virtually the same company these days. But at any rate, class action is brought on behalf of some named representatives. It could be just one, it could be more, who represent a group too numerous for joinder, who've been injured as a result of common questions of law or fact. Whether something can proceed as a class action or not proceeds on the basis of whether the 5 whys can be satisfied. And all the names end in Y, so it's not quite as easy as some of the others. But one of the commonality, right? Common questions of law, effect, commonality, numerosity. The numerosity means a group too numerous for joinder. There's no bright line. I know I've heard people say, oh, if it's more than 40, more than 25, more than 50. There really is no bright line when numerosity is established. I've had more than 20 people joined in a single complaint. I've had them named as plaintiffs. I think when you get past 50, you're probably getting in the area, but could you theoretically have one of less than 50? Not if I were the judge, but I imagine you could find someone who might do it. I still think the group is likely should be north of 50. But again, I don't think there's a bright line, because you could have one 100 or more, and the judge might say, no, I just don't see where numerosity. I don't agree with that either, but numerosity is not a bright line number. That's what I want you to know. So what we do, commonality, numerosity, typicality, that the named representative's claims must be typical of the claims that the class members have suffered, right? In essence, that they're going to be a decent representative because their claim is typical of the injury that the claim has suffered, typicality. Adequacy. Adequacy of the representation. The adequacy of the class representative to bring the claim to completion on behalf of these class members. And that adequacy, and this is where the catch-22 comes in, that adequacy is not just the named representative, but when we assess the named representative, we're asking whether his advocate, you, can adequately represent the interests of the class. So it's your representative, but it's representative and agent. And so that's why this becomes sort of an exclusive little club, because, well, how do you do your first one then, right? Well, I've never done a class action before. I'd like to do one, How do I get my foot in the door and show that I can adequately do it if I've never done it before? Well, this way, second chair one, take the case that you've got, bring it to a more experienced counsel. Now you're both counsel. You give up a little to get some more in the end. But part of it these days as well, when we talk about this adequacy issue, relates to the last one, which is really, I would think, it is the newest one. And you could make it part of adequacy, or you could just call it another one, and we're going to call it manageability. Whether it's manageable to proceed as a class here, whether that is a superior way of resolving these claims. And the manageability also relates to this other problem, which is, some of these require some significant level of accounting experience, and that may be all a backroom operation. It may not be by you, but we're talking about a little bit of money here on some of the bigger class actions. And manageability also gets into the issue of damages. It's pretty easy to have a contract case proceed as a class action. It gets a lot more complicated when, even if we take, one of the most recent ones the court looked at, which is the Walmart wage discrimination case, and say that, is that really manageable to proceed as a class when it's not a company-wide policy, but if we look at the data, it says that women were denied promotion, denied pay raises, and paid at a disproportionate rate to their male counterparts. Well, I still think that the case should have been certified. But the court said, we don't think that's the manageability of this makes sense as a class action, since each of the claims has to be individually assessed. It's harder to find both the adequacy and the manageability when it's other than a contract action, because say the Agent Orange cases, a lot of these cases for personal injuries and the like require a person-specific assessment, and that makes it a little more difficult to manage as a class action. And Unoil versus E.F. Hutton was a class action, and that's one of the cases we're going to look at today. The thing to think about, though, with Unoil as well is that it is before the change in Rule 11, which provided for a safe harbor provision as well. But that's a class action, so we'll talk a little bit about that as well. You got questions on class actions? Yeah.
If there's a class action and it's decided, and then you have a client that comes in that's typical of that class, but he missed the boat, for lack of a better way to describe it, in that class action suit, is there any easy way through, like, res judicata or collateral estoppel to attach to some?
It may be. It depends on what took place. There's a couple of examples that come readily to mind from what you said. One of which is there's various cases in various states at this point with respect to the smokers' cases.
Right.
And so the question is, well, what preceded you? And in some cases, you want to try and avoid collateral estoppel and res judicata. Other cases, you may want to take advantage of it. And part of it depends on what was adjudicated. So if there was a judgment, and again, who won, right? And you'd apply the same rules with respect to collateral estoppel and res judicata in other cases. Was there a full, fair, and final adjudication of the merits? And if there was, it's binding not only the people that litigated it, but those in privity with it. So if you want to sue Liggett on an adverse judgment that happened against them, then obviously they had the opportunity to litigate it. You would say the issue is the same. We want to establish that Liggett Myers is responsible for the lung cancer because they made Lucky Strikes or whatever the hell it was. That's a possibility. Sometimes you want to avoid it. You look at the earlier judgment and say, well, I don't want to be bound by it. Again, it's under the basic operation of res judicata and collateral estoppel that you would determine whether, in fact, this subsequent suit is barred. In some cases where there's been settlements by way of class action, and again, you've got to look at what was reduced to writing and what's the settlement. They've reserved portions of the settlement for future claims, and maybe you want to take advantage of it at that point, and there's a process within that format, earlier settlement procedure established for how you would assert your claim. A lot of it is really just taking, your basic, what you guys know is collateral estoppel and res judicata law, and then apply it to it. But here's the problem. You know, in the example, oftentimes in class actions, the reason we're proceeding is it's a relatively modest claim and not worth your investment of significant amounts of hours or expense. And so you've got someone in your office, for whatever reason, they didn't join earlier. Their claim is, you know, I had a wage claim one time. So everyone's claim is about for failure to pay overtime, failure to pay mandatory wages when due. So what are we talking, $1,000, $2,000? You know, and you're not gonna pay hourly on something like that because it doesn't make sense. You're gonna pay more for hourly than it's worth. Doesn't make sense to take it on a contingent because so I put in a bunch of hours, I get $300, $600. That doesn't make sense. And so what you hope, like you're saying, so now you've got it, you say, well, I'd like to do something, I'd like to help them out a little bit of money if there's a process set up, and they may be able to establish their claim, and just by way of making a proof of claim, showing whatever documentation they have, and they may get a payout, and that may justify, you know, you're helping with the expense. Or you may just refer them the information and let them try to do it. Part of it depends on what took place before. Oftentimes, some of these are resulting in more payouts, but oftentimes the problem is, and it's always the problem with class actions, is for those attorneys that work on the case, it's very lucrative, very, very lucrative. For the clients themselves, it's oftentimes not very lucrative at all. Oftentimes, I'll get the notice for personally for things I've done, we've done, and by the time, and I always go to see what the payout is first. There's no sense reading the rest. And when you read it, oftentimes I won't even bother sending it in because it looks like I've got to fill out 4 or 5 pages to maybe get, you know, $10 back or $5 back. And you say, well, what the hell's the sense here? And then, you know, and so the problem is the class members don't necessarily receive a lot. The attorneys receive a lot, and that's one of the bigger criticisms of it, and that's why there was at least in part, the movement to what they call the Class Action Fairness Reform Act, where it makes it easier to remove class actions to federal court now, simply because Congress at the time thought that the state courts were being a little business unfriendly with some of the class action practices that were existing. So it's actually most of the class actions brought by a relatively small group of law firms across the country that specialize in this area. And to some extent, they do so in a manner that we see with Unoil versus E.F. Hutton. And that brings up a couple of issues, so we can talk about, we'll springboard into it. Because I think, at least in part, what happened here is Joe Alioto, who's the former mayor of San Francisco, and a very well-known antitrust lawyer, in fact, represented Al Davis in his suit against the NFL, the Oakland Raiders in his suit against the NFL a number of years ago, and a number of other very, very famous suits. It was also well regarded in the antitrust area. He signed off on the complaint at the request of a lawyer who I think was far less experienced and wanted to put some iron into his complaint by using someone well known. So I guess that's my first question for you guys. So if one of your classmates calls you and they need some help on a case, they're a lawyer now, you're 5 years out, you can join them and sign that complaint? No? I can't rely on what you did, Ray?
Well, if someone came to the office and said, you know, please sign this because your name carries more weight than mine, unless I...
No, I say, Ray, I want to make you give me a little bit of money. I've done all the work, it's a pretty good case. I need you to sign on. So we'll go together.
Well,
This case on Thursday, a lawyer called and says, and it called a while back, but I just got the papers, said, I'd like you to work on this case. We've made some money in the past. We had a good case. So can I sign? No, I can't sign?
I don't think so. I think, like if they called and said, like, I want help on the case,
Yeah.
like, I'd say, yeah, like, send me something, let me take a look at it, and I do a reasonable inquiry of my own.
So like what?
What?
Like what? Like what? Because they called. I have a relatively small stack of documents downstairs now.
What type of case is
Discrimination. It's actually kind of interesting. Because part of it raises the issue of the religious exemption for discrimination claims that came up that were just released in January, because it's a private Catholic school. But I looked at the documentation. Certainly appears to be terminated. Their argument is he quit. But there's documentation that says terminated for disability. That's what it says. This is what it says.
It says he was
Yeah,
terminated on
that's what it
disability.
says. That's what it says. That's what she said it says. That's what it says.
Do you have any witness statements?
I don't. I haven't even met him.
You
Do I have,
have-
should I meet him?
Yes.
No, yeah? You have to meet, you have to, personally?
Yes.
Absolutely.
Freddie's shaking his head and says no.
Not with his
I think that
affidavit.
if you have
Huh?
a past relationship with this attorney and he's given you the package and you review it and you're satisfied, it's a meritorious claim, I would, I mean, it all depends on the history. Somebody out of the blue calls you and says, hey, I want to use your.
No, this is an attorney, no, the last, no.
But I mean, if it's somebody you've worked with, I don't see why not if you're satisfied. I don't think you have to go re-interview the.
Professor Malaguti says,
complaint.
Mike, I need some help on this case. Can I trust him?
No.
I can't trust him.
And you've got the case, though. You've reviewed the case, right?
I've reviewed what?
The case.
Well, what's the case? That's what I guess I'm supposed to, that's what I'm trying to figure out what I should have been
Deposition,
reviewing. Huh?
Maybe there's depositions done.
There's no deposition, This case is just started. Terminated in November, just started. It's in this documentation, I've got that. I've got his complaint to the NCAD. I've got their response. And it's on for Thursday, and I'm not kidding. Papers came in Monday.
Have you met the client?
No. Do I need to?
Of course.
Why?
You want to make sure he's saying and what he's saying is really what it is.
Well, can I read the papers to see? I mean, there is enough ties between what he's saying and what their answer is. I mean, I see how this shakes out now. And by the way, I've done this type of case before. Quit? No, he wasn't quit. He fired. I mean, if you know how those types of things go down. The last one with this lawyer that I did, they said he quit. And then halfway through the litigation, they're saying, no, he still has a job. And actually, they're saying that in this case too. No, that's the thing. So did he quit? Did he quit, or does he still have a job? Because you can't write them both, can you? But that's what they're writing right now. And that's what they did in this other case. They said quit, but he really didn't quit because he still has a job. He's on a leave of absence. But he walked out. And then they're trying to say he walked out. Well, he walked out because he was accused of a crime. He suffered a nervous breakdown and could not go back in this other case. I mean, so he walked out because it was either he walked out or he could have died as he saw it on the spot. So constructive discharge is in essence the argument. But that's so you know how they shake out, right? I mean, now the question is,
Quit or be fired thing happens a lot.
absolutely,
I mean,
right, absolutely,
so
right?
he quit.
And you've got a minute to decide,
Right.
right? Yeah, so he quit. Well, he didn't quit, and that's not what the way the letter indicates either, but in their own letters. So I've got some documentation. I know the law, but you know what? That latest case really sort of messes things up. The latest case says, and I don't like it, but it is what it is, right? The latest case says that if you are a religious institution, you are exempt from the laws with respect to discrimination if the person serves in a ministerial capacity. Well, it sort of is. And they left all that a little open. So he taught at a high school. So what's your question? What's he teach? What's he teach, right? English. And theology.
That's a major argument.
Well, there's my argument. There's their argument. Which, by the way, they've raised as well. So, but I mean, that's the argument, right? But so,
Wait, just because they teach the theology, they're considered part of the ministry? I don't think my CCD teacher was.
well, you may be wrong. Right, well, if it's not just you need to be a priest or a minister, but you need to serve in a ministerial capacity. Does CCD or theology constitute that? Theoretically, no. I mean, certainly it's not Spanish and math. If we just limited to that, we'd say good, or English. I would have preferred, frankly, to say, no, it's English and Spanish. Gotcha. And I'm not sure it's clear, I gotcha. But theology muddles the water, doesn't it?
What, was he getting paid?
Yes.
Was it paid?
Oh, yeah, oh, yeah. No, it was a salaried position, like a high school teacher, just happened to be a Catholic school.
And what did that case say, that he was exempt from discrimination?
Yes, that I could, if I am, and you are teaching theology,
You could be.
oh, not theology, if you were serving in a ministerial capacity and they left that open. Because I wanted, my question here was how you guys are going to avoid Rule 11, but you can help me make sure I can avoid it here too. Must you always meet with the client? Face to face? No?
No, but I would want to know that the person that's my friend had met with them.
So you can trust your friends for anything?
Not anything.
No!
Not anything.
Not, well, with your professional license?
No. I don't
Well, that's what
think
you
so.
are doing, aren't you?
No, I wouldn't do
So now we got to meet.
it. Yeah.
Yes.
Do we?
Yeah.
Even today, face to face, where we can Skype, we can
It's not
FaceTime.
possible. There are cases where the people from California want to, a firm from California wants you to sit as a second chair so they can try the case in New Hampshire
Right.
or Mass. And you're not gonna go meet with all of their clients,
No.
right?
No, but now I guess I'm wondering, because especially second chair, that means I'm signing the pleadings and I'm the local rep. I got to know what you're bringing in, don't I? So I get to review all that stuff for money. You're telling me I have to. I can't just sign on when they say, right, we need a lawyer up in Salem or Rockingham, or wherever the hell it is. But
Does the client needs to know if they're bringing in another attorney and has to agree to that, doesn't he? Or she?
oh, I think they do, and my guess is that's been cleared. That's not the issue. The issue is when you guys are comfortable that you're satisfied Rule 11.
Has the
Because I
client-
can look at the documents here and see enough of the conflict that it looks like.
Have they been deposed? Are there any?
No, this is the first really step in the process. Is the conference on Thursday? So when you guys get this call, so you're not gonna. I'm hearing you're not gonna sign until, but I don't know when the until is. Until I review all of the file, all, or enough of it to be satisfied. All of the law, or enough of it to be satisfied. Law is going with enough of it to be satisfied.
Yeah, well, I think if you can rely on this other attorney, you're putting your name on the line. If you feel comfortable enough to do that, and you've done like a reasonable investigation as to what's already been done, then I don't see why you couldn't.
Well, but isn't that what he did? Go ahead.
But I think you would have to review everything. I think if you're gonna say reasonable enough job, then the opposing side could just say, well, it's pretty reasonable to ask that you actually look at all the documents that you're gonna be arguing for, and not just, some of them to
But
make yourself
all the
feel.
law, or
I
just the
think so.
most relevant?
Well, no, relevant, but I think you should review all the documents that the other lawyer has.
But sometimes all of it could be like this. But why, God, why shouldn't I be allowed to trust someone else to cull some of the garbage up? Are you saying you can't? Because this case sort of says that.
Trust the clerk?
Huh?
Judges trust clerks to do a lot of their work, and I mean, there is some point where you have to make a decision on what's important. You have to be able to pick out what's important and what's not for you to.
But am I always vulnerable if I don't?
Yes.
Because that's what happened here, right? He really didn't do much of an investigation at all. Lawyer said, would you sign? He looked at something quickly, and by the way, there was an action that preceded it. Did look like, okay, there's antitrust violations here. He just, not for this plaintiff, right? You didn't buy, you didn't sell. Other people might have bought or sold during the relevant period, but this plaintiff isn't an injured party at all. And now he's on the hook. How much did they sanction him here? $286,000 thereabouts? $300,000 to really a great antitrust lawyer and the former mayor of San Francisco. You are nothing like that. No, right? If they do that to him, you should worry about what they would do to you if you violated Rule 11. So when one of your former classmates call you and they say, I need help, and oftentimes they need help, I'm in a mess. What your answer is, what? And by the way, I'm in a mess, I need help, but we can make a lot of money on this case. All right, let's make sure we get it right. Because I'm in a mess, I need help, and it's free. You may not be willing to extend yourself as much, right? Hopefully you will, if it's a good cause, right? But let's make it a little more enticing. Is you can do a friend a favor. You can make.
We all took that, Anthony, did you for me?
That's right, you did. So, at what point are you satisfied? What point do you need? And are all of you agreeing I've got to see the client, physically see the client?
Not physically.
Physically, with all the new methods of communication, you can either Skype it or you can FaceTime it.
Okay, but so you'd Skype or FaceTime, but I need to see the person I'm representing.
If possible.
Well, what do you mean if possible? Because it is possible these days, right? And that's my question. There's almost no reason for you to tell me you can't. No matter where they're from. Is that what you're saying?
I think it depends.
What are you saying, Geneva?
I would say I think it depends on the case.
So there are times where you will go forward without.
Without seeing them. If it's
See.
unnecessary, if the claim has nothing to do with what they look like or something like that, then yeah, you don't need to see them. If
Well,
it's-
what do you mean nothing to do with what they look like?
Like,
'Cause-
if it was, you got injured somewhere and you're doing a personal injury case, or, you know, something happened in a hospital and you're doing malpractice, you might want to see how awful the scarring looks, or.
No, it has no. There's no physical damage to
Right.
something observable.
Right, so if you can.
But so you don't need to see them.
Not if you can get all the information you need.
Can you? But can you get all? Because see, I'll tell you what I'm thinking about. I tried cases, so what? Does it matter what people look like? I'll get
Well,
no.
No, yes, and you might not want to put them on the stand.
No.
Jury's gonna look
If we're
at
talking
it.
about a case that we may have to take to trial, does it matter?
Yes.
Professor Maladuni had a case a few years back, pool dive case. Guy dove off pool into the shallow end, hurt himself, bad. Because that's what happens when you dive off the shallow end. Should you see what he looks like? Are you going to try that case or not? I mean, it's not no disfigurement. It just. Go ahead.
For me, I absolutely have to meet people. I think that you can make a.
Meet physically, or can we Skype or FaceTime? You know, use our modern technology.
If we have to, if we can't meet face to face, then modern technology can assist.
Well, what do you mean can't though? Like suppose they're in Chicago or LA, or they want to hire you. Is that good enough? Are you saying I'd feel the best if I could just sit with someone,
Yes.
which I agree with.
I
But
think you can tell.
geez,
a lot.
that might be a couple $1,000.
I
So
think you can tell a lot about people's credibility, and I'm sorry, we live in an age when people lie, so I want to meet them. I want to get a feel, and then maybe you two just don't mesh. I don't want to represent.
I don't
someone
disagree with you, but and even though a video conference wouldn't satisfy, because my guess is that's right. We could do it from Fiona's computer right here. That doesn't really cost anyone anything.
Taking a human element out that's necessary, I think, by adding technology. I mean, I'm not going to say never if I have to Skype with someone, but I really want to meet the person because we're dealing with human beings. And
But is that
issues.
an ideal? Is meet an ideal, or is meet a necessary precondition?
I think it's necessary.
Necessary.
Go ahead.
Necessary.
Go
But
ahead,
if it's
Judy.
a company, you can't have every individual in the company come and sit down and meet with you just to have a trial. I mean, you necessarily are going to have a lot of players in that situation, and I don't think you have to meet with every single one of them to see who looks good to sit there in the chair.
Go ahead.
If this guy shows up at the conference, Red Horn sticking out of his head, you question about him. But.
Well, I wonder how you justify not. If, again, to some extent, we try to practice law defensively, and all of a sudden,
Even knowing your client's not important, I don't see it. I mean, you could do the
So-
Skype thing primarily, perhaps. I think every case is going to be different, but yeah, we'll spend 2 hours talking on Skype, but when you get into town, I wanna spend a half an hour with you, I wanna do lunch with you. You know, I wanna have that meeting of the auras face to face, just for comfort. Because you never know when all of a sudden, someone's gonna bring up something you weren't thinking of. You said, do I have to read all that law? No, you just have to read the ones that are gonna catch you, okay? And you're not gonna know what they are. So, you're taking you're always taking chances.
Well, but again, what I'm hoping you guys are gonna do is not take chances that jam you up, right? Because I don't like reading about my people in the newspaper. No, I'm telling you, honest to God, okay? Right? I don't. So I wanna know how you're gonna avoid those. What were you gonna say?
Well, I was just gonna say, I mean, I don't know that actually meeting the person is actually necessary for purposes of making a factual investigation.
So what is vital? What is absolutely imperative?
The facts, you got the documents, you got.
I gotta review, well, did we decide all of them? Or, because I guess if it's either all of them or what? What's,
All
Enough
of them.
that
How do
you
you
can
draw
look
the
at it and
line?
say,
How do you
I
draw
see that
that
it's
line? How do you know when it's enough?
plain.
send me what, well, because what if the response is, well, I've got 4 boxes. I'm not reading 4 boxes for free.
Well,
All right, am I? Right, let's be honest. That's a day or two's worth of work, right? So all of them, or some of your best 20 and your worst 20? So you're gonna help me with the list. So documents, what else? Law? All of the law, or
relevance.
best, well, relevant though, that's all, then I'm depending on Fiona's judgment as to what's relevant. You comfortable with that? She's not even comfortable with that. Give me your best 5 cases, your worst 5 cases?
Well, I'm just saying that you don't need to see a person to get facts like all the time.
Now listen, let's be
But
honest,
I
and
would
you won't just meeting them won't
Well, see,
necessarily
then
give you the facts at all, right?
Yeah, I mean, like to strategize, to put your name on the pleadings is one thing. I would say that you don't even need to meet the person, but then when
But I thought that's where he got in trouble though, was by putting his name on the
because he
plea.
didn't meet the person, or because he didn't.
He
investigate
did,
the facts.
well, it appears that he did virtually nothing, right?
Yeah.
He relied on the other attorney's assertion that everything's good, which clearly, the one thing you absolutely have to take from this case is that is not acceptable at all, right? You need to make some independent investigation, because you cannot rely on another attorney's certification to you that the case is solved. That's what he did, and that was just hopelessly inadequate. So, best 5, worst 5, best 20 documents, worst 20 documents?
I have another question.
Hold on, I'm gonna get to Ray first, then I'll come over. Go ahead.
I think we're talking about exposure in the face of a Rule 11 EVO challenge against you. And what you want to do is, even if you do nothing at all, you should meet that person, because you never know whether that one sentence they speak could really determine the outcome of the case. You need to be able to have a personal feel for what you're going to put into that complaint. And when you're talking about a personal injury case or a medical malpractice case, you need to make that complaint as personal as possible. And even if that means, meeting the person through Skype, if it's not possible, to meet personally, do it. It's not going to hurt you.
But clearly though, that in and of itself, the meat isn't going to satisfy much of anything, right?
My point is that I wanted to interject is that meeting that person, whether, especially by Skype, but even in person, is probably the least of my concerns when it comes to filing a suit. It's all the facts, the medical documentation, witness statements, other things that build that case. Because 90% of the time, at least half of the stuff they're telling you isn't necessarily, it's from their perspective, it isn't necessarily a fact that you could assert, and if you do, you're screwed. It's
Without
all the
support.
other stuff that supports the case that's important. Medical, like I said, depending on what it is. I mean, the employment contract, the thing that you said, on your case, it says they terminate, in their paperwork, it says he was terminated,
Disability.
for disability. That's the important stuff, not talking to this guy and have, that's probably the least important in my opinion.
It's his perception of what was told to him and what he's telling you could be like playing telephone. Like he's telling you a totally different story than what he was actually told.
And well, it appears, by the way, already without talking to him, well, by the way, that's right, without even talking to him, just so we're clear from now. Without even talking to him, because I would assume that if you're not gonna meet, you at least better talk on the phone. But that's precisely what they're doing. There's 3 people in a meeting and there are 3 different versions as to what took place. Again, not all that uncommon. Especially, but the documentation significantly supports what he's saying, and I think is correct, is, you know, all things considered, I'd rather have the adversary's documents that support my guy's version than obviously than just his word or even necessarily someone else's, because pretty hard to disavow your own documentation and the like. Karen, what?
So is the first attorney, is he getting paid on a contingency or is he getting paid per hour?
Usually on discrimination claims and the like, they're going to be contingent. And they also, the statute will provide that if you are successful and goes to judgment, that you would be able to recover attorney's fees as part of the award as well, if it in fact gets tried.
So if you're so hesitant about wasting your time reviewing the documents, if that's the thing, you could also propose to the other attorney that they can hire you, you know, on a...
And I think that's one way to do it as well. You could do it that way, right? You could say, well, I'll review it, but on an hourly basis.
Right.
But at the same point, I'm not so sure, and I think that in part, Fred's point, I mean, I'm not sure I necessarily have to review 4 boxes of documents. If I look at your best stuff, and you give me what you tell me is your worst stuff, to get to a comfort level. So I guess I'm still not sure what you guys are going to do. It sounds like you're split on whether you have to meet. I think you have to talk at some point, review some documentation. Do you independently research the law? Go ahead.
Well, I think you can independently research the law, but isn't part of the point being missed here? You're representing a client. If you're talking to another attorney, you still don't know, and if you don't meet with the client, the whole purpose of you doing this is not for your own gain or some fact of law. It's for a client who wants something. How do you know what they want if you don't meet with them?
Hey, what
Talk
about-
to them. And what do they want out of this? Because that's really kind of the point, isn't it?
I guess, I mean, there's a fair point though. Why do we have to sort of rush the process? I mean, my artificial deadlines, putting aside, because I'm not signing any complaints on Thursday. I may go to a hearing, but I'm not going to sign a complaint. My name's not going on a pleading until we get to comfort level. But what about that? I mean, well, maybe we just don't until we've got to a comfort level. Because we know this was just completely inadequate. But, and maybe there's no absolute rule, but I guess partly this whole section I was designed to start to ask you about. I mean, are there sort of baselines here? Baselines as to what you're going to do with respect to satisfying your Rule 11. Baselines as to things you will and won't do as a lawyer. Like, would you lie for a client? So you'll never misrepresent anything to the court.
No.
Ever. That's so you'll always be truthful. That's like one of the first principles you have. I'm going to be truthful, no matter what. Is that true? I see some of you laughing or smiling, like, well, I'm not prepared to say that. You can be half and half. No.
I'm not throwing away my license by lying, you know, for any client. There's no case.
I hope you're not going to lie for
There's no
clients.
case worth that. You know, now do attorneys like omit, like?
Oh, that's not a lie.
No. I mean, if there's no misrepresentation of a fact, there's things that you don't have to disclose, you know, that I'm sure attorneys on a regular basis.
So an omission isn't a lie.
No, but if it depends on the context, I guess. You know, if it's.
This is waffling in the third degree.
No.
Yeah. So
No.
you won't affirmatively misrepresent something.
If you know there's something detrimental to your client, you're not going to tell the other side unless
Agreed.
it's in the form of discovery and you're
Unless you have to, unless you're obligated.
Right, that's my point in omission isn't a lie if, even though you know there's something that, if they knew about this, we'd be in
Well,
trouble.
when the court asks you a direct question,
You don't lie.
okay, but again, okay, we're agreed to that, okay? Ever, because you lie once, then you're a liar, okay? But as lawyers, it seems to be we're having a disagreement about then what's a lie. So is an omission when the court asks you a question and you know the answer to it and you know the answer is adverse and you admit that portion of it, or try to misdirect the court in a different area?
No, you can't do that because your first obligation is as an agent of the court.
Is it? Is it first obligation of the agent of the court or the client?
Court.
Oh, is my
Court,
answer
you
to
got
that
that somewhere?
question
Huh?
covered under
That's
attorney-client
a-
privilege?
What?
Is my answer to their question covered under attorney-client privilege? So can I claim that, so I don't have to answer that question?
No,
So that I'm
I-
not lying?
No, I think, go ahead.
We had an example in one of my other classes where, say you were arguing a motion and you were arguing case law, and you came across a case that was actually detrimental to your motion.
Correct.
Would you mention that, and then the other attorney wasn't as well equipped and they missed it, but would you bring that to the court? And a lot of people are like, no, it's not your job to do the other attorney's job. But then you have a judge sitting up there who's gonna know if you know it or not, and that's your reputation.
So the answer is, when Fiona doesn't do her work and I find that case that helps Fiona, I have to make my great argument and say, Fiona sits there and goes, and then I have to say,
As a lawyer.
Fiona should win because of this case?
No, you have to.
Geneva
argue.
says I'm not doing
No,
that.
you don't do that. You would just distinguish it. You put it up
Yeah.
front so it makes you look better.
Yeah,
And
you have to
say,
argue.
this is what they should be saying, but however my case is
Why should I even
distinguished.
distinguish it if Fiona hasn't found it? I have to? I have
If
to
it's-
tell you about authority that the less skilled advocate hasn't found?
All they've been telling us is, all you have is your reputation in this.
Oh,
case.
listen, I agree with that completely. I'm just not sure I have to argue Fiona's case for her when she's ill-equipped to do so. Huh?
You don't need to argue it for her. You just, if that is a case that is prominent law that is going to harm you, you don't want to be caught off guard if the court then asks you about it. You want to add that in if you can to help your case. It doesn't matter if Fiona.
But you know, I know some lazy-ass attorneys like Fiona. They're gonna go through all those cases I cite in my brief to do her research. And then she's gonna find that one that I've tried to distinguish and draw the sting on, and she's gonna say, ha, now I've got a case. So I understand what they were telling you. I'm not so sure I'm gonna give her the golden goose until I know she's got it. And then I can distinguish it. And I do recognize your obligation to make sure that the court is aware of controlling authority. But let's be honest, we've all been in law school long enough. It's a lot more shades of gray than controlling authority. It's rare that we find a case dead on, all square, right? So, and since I'm going to distinguish it, since Geneva says I should distinguish it, then I assume it's not controlling anyway, because it's distinguishable, right? So I don't need to mention it at all. If it's distinguishable, it's not controlling. Is it? That's, I would think, at least in part, that's the way that logic tree works. So let's get back to, you won't lie to the court. Good. You don't lie to the other lawyer? No? So when you say your client won't take a penny less than $1 million, you mean? I want to know. Oh, that's not a lie either? That's what? What's that? Oh, no, is that true? That doesn't count as a lie? Because I'll tell you, I have lied. Okay? No, really, right? I got if I tell you what my bottom line is out of the gate, I'm going to get half my bottom line, and then we're never going to settle it. Huh?
They call that gamemanship.
So that's not a lie either. Listen, I'm 25 years of practicing. This is the client who is telling 110% the truth and deserves every penny they get. So that's not lying. I mean, that's not lying when you tell them what your number is and it's not your number. You're kidding, all right? We know that's a lie, right? That is a lie. You tell me your bottom line is X, and it's somewhere below X. That's a lie, right? Well, we can at least define that as a lie, can't we? A lady saying no, you can't.
Well, that's a bargaining
That's a
process.
standard, yeah, bargaining process that all lawyers are aware of.
It's still
So.
I don't disagree with you, but it's a lie, right?
Wait, the other person's aware.
The other person's gonna lie back, so it's different.
They're all liars.
So is that what it is? We can't even define appropriately what a lie is?
It's honesty among thieves. That's all.
But it's not honesty at all, right? It's a lie. So do I now take it that you will lie to other lawyers on behalf of your client, but they'll be well-intentioned lies? Yeah. No, because they are lies, correct? Because a minute ago you told me you would never lie to another lawyer, but you're all saying, no, that's an acceptable lie. Right? Does anyone disagree with that? By the way, you tell me what your and I'll be honest with you, you tell me what your bottom line is, then I'm going to get, you're getting less than that anyway, because I got to feel I've done my job. So I'm not giving you whatever you tell me your bottom line is. But if I believe it, you might get close to it, because I realize that we got to get close to there to make you happy. But you're not going to get that. And by the way, if you tell me that's your bottom line, you're not getting a penny more. Right? No, my bottom line is I got to get $1 million. Bigger, I'm not offering you 2 now. No, really, right? So, right, that's the other part of this. So your principles that in which you're going to conduct yourself, you will or won't lie to other lawyers on behalf of your client.
Well, it depends how much of a disservice it will do you if you get caught.
You know this topic is first principles, right? Principles. Like,
You're not gonna play this for Professor Olson, are you?
no, we won't play this. No one else will know what goes on here today. No, but the point of the dialogue.
Stop referring to us by name.
Which
Continue to say Ray's
and
name.
this is why it's not downloadable.
Oh, sure.
Here's my question. Seriously, it means to provoke a serious thought process for you to engage in. What is it you will and won't do on behalf of your clients? How is it you will or won't conduct yourself as you practice law? Because I really think that that's important for you to start to think about, like where do you and the lawyer, you as a lawyer meet, at the end of the day? Like what? Because people will ask you to do things that you better be prepared to know where your line is, right? I mean, I'll give you an easy one, okay? Oh, can you notarize this for me? Well, is it your signature? No. Well, who is it? Oh, it's my wife. But even my wife, right? It's my wife's. Well, when I'm notarizing something, I'm saying the person signed it before me. And so, I can tell you a bunch of cases where people did that on a mortgage or a deed and found out it was the girlfriend instead of the wife, and now they've gotten in big trouble. So I mean, there's some easy things that you have to decide, but I think there's even more difficult things to decide. Like, will some of you do criminal law? Will you represent drug dealers? Drug dealers in a school zone? Child molesters? Are they entitled to? And I don't disagree with that. By you? By you? And that's the thing. I just want you to start. So what? Where's your line? Right? That's all I think you have to start to think about, because you should have some basic principles as to how you will conduct yourself going forward. Because it seems to me I'm hearing a lot of waffling. You aren't going to lie, but only if it helps. Right? And it's well intentioned.
There are lies and there are lies.
Well, but is that true? Really, at the end of the day, is that true? Because either you will or won't lie, or you're going to say, no, I'm going to lie, but these are the lies I'll make. And that's because you can't fudge it. It's not. It is a lie, right? I mean, we don't disagree on that, do we? It's a well-intentioned lie. It's a what do we say? A white lie, right? White lie, is that what you call a white lie? Because my heart was pure, right? No, it's not where it comes from. My heart was pure when I lied, right? But that's the theory, right? So what else will you or won't you do as you start to think about it? And not just with the case. I mean, you're gonna return all those phone calls every day, write those letters all back. Listen, I wish I could respond to every email, but I type like this, 2 fingers, so I try, but I don't do a very good job.
Pick up the phone and call people.
So pick up the phone and call them back.
Yes. Or
You
your
go- I know some
paralegals
lawyers
may
that
get
say, I'm
really
gonna return
upset.
every call by the end of the day. You? Is that something you intend to do? I think it'd be good if you do it, and you would have far fewer complaints from clients if you did. But with the reasonable caseload in some clients, that becomes can be a problem. Some days you don't necessarily want to finish your day like that. Go ahead.
The attorney I worked for in New York, he gave, I don't know if this was, I don't know what to call him for doing this. He gave his office number, his cell number, and his home number to his clients.
I call that stupid.
So,
Well, let me ask you about that. Would you give them your cell number?
No.
What if they ask? Oh, you have a business cell. You're just gonna have.
Real good case.
Here's my cell, but you're gonna get the business cell, and that's going off at 5:30. No, is that true? Because I think especially today, as you guys go to practice, people are expecting to have your cell, right? That's something you need to think about, and you'll see it on business cards now, and so it's not unexpected. And why don't you give me your cell, right? Or here, you can have my cell. It's the easiest way it is the easiest way to reach me. I don't answer the whole phone at home half the time, right?
he returned every single call that came in. He wasn't the type to say, oh, I'll call next week. If call came in, leave a message, call him right back.
So, where do you guys stand on the cell? Can I have your cell? You're gonna give them the cell?
Like, you know, business.
Does everyone, huh? Does everyone already have your cell?
I don't want somebody having access to me 24 hours a day.
So no cell?
Absolutely
Or business
not.
cells,
Absolutely
We're
not.
not saying it.
Well, so then when I ask for your cell, how's the conversation go?
I have your cell phone. If I need to get in touch with you, that's fine. Or I'll have some way for somebody. You can email me.
Answering service.
What if I need to reach you in an emergency?
Email me. My phone pops up every time I get an email. You don't need to call me at 3 o'clock in the morning because, oh my God, I'm having an anxiety attack. You need to add this to my claim. I don't want to deal with that. Absolutely.
So you're gonna say, no, I don't give out my
Yes,
cell?
yes. I have email that I check regularly.
You don't check it at 3 a.m. when I need you.
Actually, my phone dings when I get an email, so yeah.
Well, but see, I'd be honest with you, I didn't think that argument was so good, because if your phone dings, then you might as well give me your cell phone number. So that's.
Because then I have the choice of whether your emergency may not be my emergency.
So are we gonna have this while you're trying
I've
to?
had this conversation
Stick
with
your hand in
people.
my pocket to take big
I've
money
had
out of
this
it?
conversation with people. Why don't you give me his cell phone number? No.
Well, I would just say you'd have to ask him. I'm not permitted to give
He
out his cell
doesn't give out his cell phone number. That's what I've been told to tell people. He doesn't return calls anyway, so it doesn't matter.
So I mean, because there will be clients that will want access like that, and I think today, especially even more so, that's almost a given that they're looking for your cell. And listen, we can sit here in a classroom and say, yeah, I'll give it out. When I represented the teachers in the Boston Teachers Union, we were on call 1 weekend a month, and so the calls would be 2, 3, 4, 5 a.m. And they were not, put this in my claim. It was, can you come down to the station? No, really, right? I mean, let's be honest. You have a lot of people to represent. There are things that happen don't often happen between 9 and 5. Really bad things, and so I mean that was part of the requirements of the firm. And the client we had, that was the agreement. We would be on call 24/7, and someone had to be there. So is that you? Because
As long as I was getting paid.
well, you'll get paid, but you may also be going out at 2 or 3 or 4 a.m. Or they're going to be wanting advice. Do I take the breathalyzer? Do I take a blood test?
No.
Well, you better. By the way, you better have an answer, right? Because the point of you being available is so that you can provide such an answer at that time. Do I take the chemical test?
How coherent
How do
are
I
you
get a
being
restraining
in
order? Huh?
How coherent am I gonna be at 3 in the morning? You're gonna trust advice you get from someone at 3 in the morning?
Well,
I
so is
wouldn't.
that your rule? Come 8 o'clock at night, advice time's over? No, listen, I don't care what you decide your rules are, but you want to establish what those boundaries are. I've asked you guys before, you're gonna represent family? Listen, you can shake your head now and say no, but the fact is you're the lawyer in the family at the end of the day, right? And that's part why you went to law school, if I read your personal statements right, is to help people, but not the people closest to you. No, really, there is a real disconnect there, just so you know. No, I want to help strangers, not my family. But like it or not, it's you they're looking for help from in times when they need it. And again, if you don't have lines as to what you'll do for others, family's worse because they'll oppose you as the little brother or the little sister, or my cousin will take care of this. And so they're expecting you to do, and yet even have to have, I think, more definitive boundaries there so that they know, listen, if you're a client, you do what clients have to do. You either take the advice or you can reject it like other clients, but the rules aren't any differently as to whether I'm going to notarize something for you when you're not here, or whether I'm going to lie to the court for you, or I'm going to do this or that. The problem is, I think there's a greater expectation on your own behalf that you'll perform and do well, because you don't want to be, a family lawyer who sent Uncle Jimmy to prison, or mess up the house closing, or whatever it is. But I think at the same point, the reward there is there as well, not financial, but the reward is there is that you can help your family members, that they recognize why you did these things, why you went to law school. I want to talk a little bit about First Technology Safety Systems, which is in your package as well. And I think this is a very interesting case because I don't think, for the most part, I know I didn't teach it in civil procedure, I don't know that Professor Martin did, but this is an attempt by way of an injunction to seize the evidence before it can be destroyed. And even more importantly now, especially when we think about, this is physical evidence, but when we think about electronic evidence and data and all the rest of it, soft copy stuff, even though in federal court there is a mandatory, once suit is filed or a suit is reasonably likely, you are required under the modern rules of discovery, the recent changes that were a couple of years ago, to preserve the electronic data and not allow any further loss of that information. And that's going to rest on both you and the client. And your obligation, and it's under Sarbanes-Oxley Act, your obligation is to make sure your client is educated in that regard about the preservation of electronic information. So, and you need to understand that seriously, because you'll consult with the client and you'll know litigation's likely, either they think they're going to be sued or you're going to be suing them. And once that situation arises, you have to educate them that they are not to dispose of information anymore. I mean, if you think about it, and I really wonder how the courts will ultimately deal with this. I must delete 30 emails a day. Right? And I don't delete much, and I've got 30 pieces of junk every day. How do you, if you have a business like that, how do you know, how do you make sure all the employees know, unless you're certain it's absolute junk, you can't be deleting stuff. Even if we have a regular system to destroy older emails, older documentation, older documents, just as a matter of course, the system is set to purge itself. You got to be careful with that these days under the modern rules of discovery. And that's your job to educate the clients. What this was, though, is this was an attempt by one company to seize the evidence by way of an injunction at the outset. Because they were concerned that if the evidence wasn't impounded, that much of it would be lost or destroyed because they already stole the crash dummies, and I bet you didn't even know there were 2 crash dummy companies. But they stole certain proprietary information, as they saw it, from the other company in order to establish the new one. And so if you look at this case, what they did here was pretty clever. I think also pretty heavy-handed attempt to force the other company out of the business immediately. And I think this happens a lot with non-competes and other type of business disputes, where they go in for an injunction, and the injunction will, in fact, if granted, and the information is obtained, may well be the absolute end of the case, period, because of the manner in which it happens. Here, if you look at the case, and it's a case worth looking at because you don't see a lot of cases like this. Here, if you look at it, not only did the court allow the seizure, but then the marshals couldn't actually keep the information that was seized, so they allowed plaintiff's local counsel to store the information that had been impounded and seized. So not only were the defendants unable to use their information, but it was immediately, instead of being held for safekeeping, turned over to the plaintiff's lawyers so that they could use it, examine it, and do whatever they wanted with it. And this was done ex parte, as you'll look at as well, which means without notice to the other side, which is not that unusual when we've got a theft situation, if you think about it, right? I mean, if they already have stolen stuff, and I give them notice of the motion, if they're thieves, they're likely going to destroy, conceal, or hide the information. And that's the justification for the ex parte order. The problem here is, not only was the order ex parte, there was too much stuff seized, and then what happened is they didn't take care of the information. What they did instead is allow the plaintiff's lawyers free access to it. This is, I think, a very good case because we don't see too many where the court allows the seizure of evidence at the outset, and it is permissible generally, wasn't permissible here because of the manner in which it was done, and there are a couple of real problems with it. The amount of the bond is relatively low. The bond is set by the court, and we're going to look at this in the next section as well. The court has to set a bond under Rule 65 in the event the injunction is later determined to be improvidently granted, meaning it was a mistake. The bond is supposed to be there to compensate the non-moving party for the damages they suffered as a result of the injunction. Here, all the information was seized, including the dummies. $2,000, while not much, the defendant saying is really insufficient because the value of the stuff seized and copied exceeded $2.2 million. Here the court said they didn't think the $2,000 was that far off. I really don't quite understand that part, if in fact the goods were worth as much. The problem is the court still is in error with the manner in which this seizure took place, even though it does talk about on page 650, 651, under what circumstances the ex parte injunction can be granted. And if the notice to the other side is going to result in them destroying the information, then there may well be a justification for that seizure ex parte. I'd like you to look at a couple of the other articles and think about some of the topics we discussed today, because I think there are other cases within this, and there's a couple of other articles that I think are worth thinking about. The lawyers and their games are leading us down the tubes, which is an old Globe article, I think is something for you to think about as to how you're going to either respond to those types of criticisms that we lawyers get, or recognize that not all lawyers have to practice law so that they're seen as sleazy and without values. And then last, the article in the sequence that I wanted to really think about is if you don't have sufficient technological expertise. I think there's some suggestions in the last article that really make a great deal of sense. One of them, one of them says, spend no less than 10% of your professional time developing and improving technical savvy. You know, the fact is there's a lot of experienced lawyers out there who are very experienced at trying cases, drafting wills and trusts, and doing those types of things. But this whole modern technology is something that, okay, I recognize I should be doing something with it, but I don't know what I'm supposed to do. If you leave law school having a decent dose of technological expertise, you are familiar and comfortable with the new forms of media, your Facebook and Twitter and website development and things like that. And we don't have to be an expert to be good at this, right? I mean, and that's the thing, you think, well, I don't know how to build a website, or I don't know how to get a professional appearance on the web or on Facebook or whatever. Yeah, you do. You probably know a hell of a lot more than a lawyer who's been out there 30, 40 years practicing law, because they don't know what Tweeter is, and you at least hopefully are ahead. I know. Hopefully ahead of that path, right? And, no, but this is the point, right? In the land of the blind, the one-eyed man is king. You only need to know more than the lawyers that you're going to go work for, and you really should spend some of your time trying to think about that. One thing I've always said to people at this point is, as you start to think about taking this article to heart and really thinking about technology, where you go with it, is do you have a professional email address? Do you? Because I get some of them and I'm surprised, you know, like Italian769 at AOL.com. That's not, no, I'm telling you, you know. Someone said, I was at a seminar at Northeastern, I think, seriously, it was worse than this, but it was like, you know, hot and heavy at gmail.com. And that's on a resume, right? And sometime soon, you're going to go looking for jobs, or you're going to be entering the professional sphere. At the minimum, get yourself a professional email address. I also think, those of you that are thinking of practicing law on your own or in a small firm, I own a number of different websites, but I was late to getting my own name. I don't have michaelcoin.com. I wish I did. Your name may be available, and it's about $10 a year. So there are things to think about. You go to Google cheap domains. It'll bring you to a special at GoDaddy that's going to cost you for the next 2 years for your name or something close to it, about $20. I know what you spend for law school tuition. I know what you spend for law school books. It would seem like this may be the time to start thinking about what your professional online presence looks like as well, for relatively modest expense. So I think you need to start to think about this part, okay? So, and figure out how you're going to develop it. I'll talk to you later. Thank you.